Picture this. Jamie walks into her neighborhood grocery store. She grabs a cart and starts walking up and down the aisles, collecting what she needs to make dinner. Suddenly, her right foot slips forward. Next thing she knows, her body is off the ground before her head and back come crashing against the concrete floor. Dazed and confused, she feels wetness on her hands and clothes. She looks around and notices the puddle of liquid that caused her to slip. A day does not go by without someone calling us about a potential slip and fall case. According to the National Safety Council, over 35,000 people died in a slip and fall accident in 2019. More than 9 million people visited a hospital for injuries related to a slip, trip, and fall accident. Slip and falls account for more severe injuries than car accidents. More traumatic brain injuries are caused by slip and falls than any other cause. Locations such as grocery stores, malls, restaurants, hotels, movie theaters, and office buildings all have a legal duty to make their property safe from harm that is reasonably foreseeable. So why are slip and fall cases considered so difficult to win? The simple answer, as I will explain, is that slip and fall laws are more favorable to the property owners. After you watch this video and understand why slip and fall cases are difficult, make sure you click the link to the video where I explain how we actually win slip and fall cases. Now, saying that there was a violation of the duty of care is one thing, proving it is another, and here is where the difficulty comes in. The burden of proof is on the injured person to prove that the injuries were caused by the negligence of the property owner or manager. The property owner or manager does not need to prove anything. Okay, but what if it's undisputed that there was water on the floor? Wouldn't that make a store or property owner automatically responsible? You would think so, but unfortunately, no. In a slip and fall case, the injured person must provide evidence that either the property owner or manager, through its employees, either 1, created the dangerous condition, or 2, knew of the dangerous condition before the slip and fall, or 3, should have known about the dangerous condition before the slip and fall. Think about that for a moment. Just because there is liquid or some other hazard on the floor is not enough to win a slip and fall case. The difficulty in slip and fall cases is due to the fact that the law places the burden of proof on the injured party, not the property owner, and often comes down to the lack of readily available evidence. In comparison, proving fault in a car accident is usually much easier because favorable evidence is usually more readily available. There are often witnesses, camera footage, police reports, and photos of where the cars came to final rest, along with photos of where the cars were hit to help prove who was at fault. Now let's take a closer look at what is needed for a property owner to be found at fault. Scenario A is where someone who works for the owner or manager of the property created the dangerous condition. An example of this would be where an employee is stocking items in a grocery store and does not realize that he or she dropped a carton of juice on the floor and it leaked. Unless the worker comes forward and admits that he or she dropped the carton, it may be difficult to prove that it was the store employee's fault, unless there was a video camera that captured that area of the store. Some store employees will be hesitant to admit fault out of fear that they could be fired or reprimanded. Scenario B is where there is evidence that the property owner actually knew of the dangerous condition before the slip and fall. This requires actual knowledge. For example, an employee sees a spill but is too busy to clean it up before someone slips. Or an employee sees a spill but leaves the area to get a mop without putting out a cone or a warning and someone slips while the employee is getting the mop. Similar to scenario A, unless there was video coverage, proving what happened can come down to whether the employee is honest and admits what he or she knew. Scenario C is where there is no evidence that the property owner or manager actually knew of the dangerous condition, but there is evidence that the property owner should have known of the condition before the slip occurred if the property owner had acted reasonably. This might occur if a store did not have reasonable policies and procedures in place to periodically walk around the property looking for dangers, Or a store might have reasonable policies and procedures, but there's evidence that they were not being followed. For instance, a store may require that someone inspect the property every hour. However, there may be evidence that no one actually followed the policy. For example, there may not be any documentation in the form of a sweep sheet or checklist that anyone was regularly doing the inspections. Similarly, video surveillance might be used to show that the property inspections were not actually being performed timely and properly. In this scenario, the judge can instruct the jury that it can infer that if the property owner's employees had acted reasonably, it should have had enough time to discover and correct the danger. Again, the key point is that unless there is evidence that the property owner created or caused the danger, it isn't enough to show that a person slipped on a liquid and was hurt. The injured person must also show that the property owner had a reasonable time frame to discover the danger and take appropriate action before a slip and fall occurs. In Jamie's case, it will not be enough to simply show that she slipped on a liquid and was hurt. Without any evidence, it could be entirely possible that another customer spilled some water on the floor 5 minutes before Jamie slipped. If an employee was not in the vicinity, that might not be enough time for a store to discover the spill and do something about it. The law places the burden of proof on Jamie to produce some evidence that the property owner was negligent. Keep in mind that in a slip and fall case, it does not matter how badly someone was injured unless the injured person can prove by evidence that the property owner was negligent. This can lead to very harsh results, which is why I said that the law favors the property owner by placing an unfair burden on the injured person. For example, Jamie may have suffered brain damage when her head slammed against the concrete floor. But if she cannot provide some evidence that the store was negligent, she would not be able to win her case in court. The law adds another aspect to make slip and fall cases difficult to win. This is the legal concept called comparative fault. In any slip and fall case, the defendant property owner gets to argue that the injured person was negligent by being careless. The property owner can argue that the hazard was open and obvious, and the injured person should have seen it if he or she was being careful. The property owner could try to argue that the injured person was not paying attention, or perhaps talking on the phone. In Nevada, the significance of comparative fault is that if a jury finds that the property owner was negligent, but also finds some fault on the part of the injured person, the judge will instruct the jury to apportion a percentage of the blame to the property owner and a percentage to the injured person. After the jury renders its decision, the judge will deduct the injured person's percentage from the verdict. For example, if a jury awards $100,000 but finds that the injured person was 40% at fault, then the verdict will be reduced by 40% to $60,000. Importantly, in Nevada, if a jury finds that the injured person is more than 50% at fault, the person gets nothing. So if a jury awards $100,000 and finds the injured person 50% at fault, the person will still get $50,000. But if the jury finds that the injured person was 51% at fault, only 1% more than the prior example, then that person gets nothing. As a reminder, after this video, make sure that you click on the link in the description section below where I explain how we actually win slip and fall cases. To summarize, slip and falls are often difficult to win because the law places the burden of proof on the injured person that the property owner was negligent by either creating the danger or that it had a reasonable amount of time to discover and correct the dangerous condition before the fall. This requires actual evidence which often is not readily available to the injured person. In a worst-case scenario, there is no security camera footage of the events leading up to the fall. No one was around to witness what the store employees did or did not do before the fall, or there is no circumstantial evidence that can be used to argue that the property owner should have known of the danger prior to the slip and fall. Unfortunately, the worst case scenario is very common, which is why it can be difficult to win slip and fall cases. Since slip and fall cases are often difficult to win, it's essential that you hire an experienced slip and fall lawyer as soon as possible. They will be able to gather as much evidence as possible and present your case in a manner that sets you up for the best chance of success possible. Without an experienced slip and fall lawyer, your chance of winning your slip and fall case is very low. I hope that you found this video helpful. Please subscribe to this channel to get more useful legal information. Click like and share with friends. And remember to click on the link to the video on how we actually win slip and fall cases.